Contribution on this Disputes Tribunal Amendment Bill, and as several people have noted, Labor obviously will be supporting this bill. It's a sensible, small piece of potential legislation that makes a difference to real people who are going through a disputes process. Mr Speaker, the Disputes Tribunal Amendment Bill, as has been said, simply raises the cap from 30,000 to 60,000 on the awards that tribunal, the Disputes Tribunal, can make. And as has also been said, it's a really important way, therefore, to make that justice and that recompense accessible to people, because for a lot of people their only experience of the justice system is through a disputes process, and for people to have faith in the system as a whole, they want to be able to seek that redress in a way that makes sense and that is efficient, cost effective, and doesn't do more harm than good, so to speak. So at the moment, the fee of $59, as I said, therefore does make it accessible, and I think many of us in this House possibly have experience of going through a disputes tribunal, or know of people that if something has happened, whether it be the tenancy tribunal for some people, but the disputes tribunal in this case, where people have sought to get what's owing to them, or sought to right a wrong that has happened, and it's incredibly stressful, and it's something that you have to do yourself, and it's something that you have to take the lead on. There's a lot of unfamiliar language, there's a lot of unfamiliar process, so anything we can do to make that better is good. So the bill will mean that losing parties in the tribunal will also have to pay the cost of that filing back fee to the applicant. And I note that when the the claim is between 30 and 60,000, that fee is significantly higher. I suppose with an eye to preventing frivolous claims, so that people will think twice about pursuing claims that are frivolous, and particularly when you can imagine when there's a power imbalance, and it may just be, they may think it's worth their while to do so, but if that had to be paid for them, if they were to lose, then that kind of evens up that process a little bit. It's not a perfect bill insofar as, I think someone said earlier on, it's a little bit of a missed opportunity perhaps to have done a couple of things differently. There are a number of issues with the bill, but nothing that couldn't be sorted out through the Select Committee process, and I'm sure it will be there. If I remember correctly, I think the Honourable Dr Duncan Webb said earlier about there not being the right of appeal, which obviously is an important part of any process and should be no less important in this process. And it doesn't increase the cap to the level that had been suggested by that Rules Committee recommendation, which of course is the impetus for this and where it comes from. But as Helen White has just talked about, at what point, where is the happy balance between that cap being too high and not high enough? So all things that can be discussed during the Select Committee process, and hopefully there will be some submissions, and hopefully we will have some scenarios and some stories to sort of flesh out some of the pragmatics around this bill. There is a need to balance the benefits of what is a quick, cheap and cheerful sort of informal justice process with something that could be a little bit more robust, and the ability to correct error, as I said, with a potential of an appeal rights process through the courts. And I think that that will be quite interesting. So, Mr Speaker, as I said, the bill in itself is simple. It stems from some recommendations, and so has already come from a relatively good place in terms of process. So Labor commends this bill to the House, and we look forward to the Justice Committee doing its thing and reporting back in due course.
I think Tracey may have slightly misrepresented there. You can appeal, but it does now if you appeal within the tribunal, it's free of charge. But if you appeal outside the tribunal to the district court, that's when there is a substantial fee increase.
Which kind of makes sense, to be fair.
Yeah, so I think that might be, but it is known as you cannot, if the district court judge agrees in the application with the tribunal referee, you're kind of stuck with the decision. Because I did hear there was this one professional landlord who pretty much takes every single tenant they had to the tribunal, often would go to the district court section if she didn't get away. Right. Yeah, so there are some people out there who are professional